BetZedek is an LA-based community nonprofit that provides justice, stability, and hope to those experiencing economic and social disparities. BetZedek provides free legal services, educates community members with the powerful knowledge of their legal rights, and uses our collective voice to reform systems. Our vision is to achieve equitable access to justice so that everyone can meet their essential needs and lead fulfilling lives. Small businesses are a key part of local economies and infrastructure. BetZedek's Small Business Development Project supports small business owners through legal representation and educational resources. We partner with the County and City of Los Angeles, pro bono attorneys, business community groups, and economic development organizations to provide free legal education, resources, and one-on-one legal assistance to low to moderate income small business owners and entrepreneurs. BetZedek launched its Small Business Development Project in 2016 to strengthen the economic base of underserved communities, including women, disabled, veteran, immigrant, limited English-speaking, LGBTQ, and BIPOC business owners. BetZedek's Small Business Development Project can help small business owners and entrepreneurs with forming a business, leasing commercial space, understanding contracts, fair employee practices, protecting their intellectual property, and more. Contact BetZedek's Small Business Development Project by visiting lalegalhelp.org or calling 866-375-9511. We offer services in different languages. I am Marco Castaños. I am a staff attorney at BetZedek Legal Services. I work on the Small Business Development Team, or SBD, as part of BetZedek's dedication over 50 years to providing free legal services to low-income Angelenos. Our team supports the legal needs of small business owners and entrepreneurs. This video was brought to you in partnership with the City of Los Angeles Economic and Workforce Development Department and BetZedek Legal Services. BetZedek is an equal opportunity affirmative action employer.
The Economic and Workforce Development Department's goal is to steer economic development in a manner that yields thriving businesses and creates job training and career opportunities for the City of Los Angeles. EWDD works every day to deliver a strong and committed workforce, maintain sustainable neighborhoods, and profitable communities throughout Los Angeles. Get more information at ewdd.lacity.gov. The City of Los Angeles Economic and Workforce Development Department, or EWDD, funds 10 business source centers across LA City. Business source centers offer free business consulting and technical assistance to help startups and operating businesses with permitting, access to capital, and marketing, among others. Services are provided at no cost to LA City business owners and resident entrepreneurs. Get more information at the link on your screen. Thank you for viewing this educational video. The information provided in this video is intended for general informational purposes only and should not be construed as legal advice. While we strive to present accurate and up-to-date information regarding small business laws and regulations in the state of California, laws are subject to change and may vary based on specific circumstances. Viewers are strongly encouraged to consult with a qualified attorney for advice tailored to their individual situation and to ensure compliance with all applicable laws. The content presented herein does not establish an attorney-client relationship, and we assume no liability for any loss or damage incurred as a result of reliance on the information provided in this video. You should decide which course of action is best for your small business after thoroughly discussing your case with a qualified attorney. Thank you.
Today, we are addressing two related topics. First, we'll cover new legislation for certain commercial tenants called the Commercial Tenant Protection Act of 2024, and we'll discuss some basics to commercial leasing, so future small business tenants are informed about what to expect. This is really a major issue in our work. We work with so many small businesses that are behind on rent or looking to terminate their lease early. We work with them based on the terms of their lease, and oftentimes they're surprised about what's in there. I want to help people identify and negotiate important terms at the outset so they can operate as more informed tenants. The commercial leasing landscape is much different from the residential context. In California, residential tenants are afforded statutory protections as outlined in our codes. For instance, there are situations where residential tenants can invoke repair and deduct as a legal strategy. such is not the case for commercial tenants. Most commercial tenancies are governed entirely by their written lease, at least until January 1st of this year when the new law came into effect. The Commercial Tenant Protection Act, known as Senate Bill 1103, was authored and introduced by California State Senator Menjivar in 2024 and is in force beginning January 1st, 2025. It's a first-of-its-kind law to grant basic statutory protections to certain commercial tenants. It addresses rights for what are called qualified commercial tenants, and it's on matters of language access, minimum notice periods for month-to-month tenants, and building operating costs. Qualified commercial tenant is a legal term defined in the law as either a micro-enterprise with 5 or fewer employees, restaurants with 10 or fewer employees, or nonprofits with 20 or fewer employees. With respect to language access, if your commercial lease was negotiated in Spanish, Chinese, Tagalog, Vietnamese, or Korean, your landlord must provide you with a written lease in that language. For month-to-month tenants, SB 1103 also establishes minimum notice periods for rent increases and lease terminations, as well as approved methods of service. And it establishes a procedure for landlords to charge building operating costs, giving tenants certain audit rights over how such costs are calculated and allocated. There are legal remedies that are also outlined in the law. For instance, if you negotiated your lease in one of those languages and your landlord fails to provide the translated written lease, you may rescind the contract, which means terminating the agreement early and putting the parties in the same position they were in prior to signing. And failure on the part of the landlord to follow the minimum notice rules or the procedures for charging building operating costs can be raised by the qualified commercial tenant as a defense to a civil action for damages or eviction. We are really excited about this law because it's the first time that commercial tenants in California will have rights enshrined in our state law. If you are a qualified commercial tenant, there's a few steps you need to take in order to exercise your rights under the new law. If you want to enjoy these rights, you must notify your landlord in advance. You must tell your landlord in a signed writing that you are a qualified commercial tenant and provide a signed self-attestation on your number of employees. You must provide this notice and attestation before or upon signing the lease and annually thereafter, as long as the protections apply to you. With respect to the notice requirements, if you have a month-to-month lease, and you have provided the notice and self-attestation, then rent increases greater than 10% must be noticed 90 days in advance. Rent increases of 10% or less have a 30-day notice. No-cause lease terminations must be noticed as follows: 30 days if the tenant has occupied the property for less than a year, and 60 days if the tenant has occupied the property for a year or more. Worth noting, the landlord's notice is also governed by California law and includes requirements on serving notices by mail and in person. With respect to building operating costs, again, the tenant needs to have provided the notice and self-attestation. Building operating costs cover the operation, maintenance, and repair of the property. If your commercial landlord intends to charge building operating costs, then they must provide supporting documentation. That's in the form of dated and itemized quotes, contracts, receipts, or invoices from licensed providers. These must include, first, a showing of how costs are shared between tenants, and second, a signed writing by the landlord that the documentation is true and correct. Having discussed SB 1103, I'd like to jump into the next phase of today's conversation. I want to discuss certain basics related to commercial tenancies and commercial landlord-tenant law. I want people to consider outlining their approach to finding a commercial space, and I'd like to share some notable terms common to many commercial lease agreements. By outlining their approach, I mean a series of steps to commercial leasing, which include important dates, procedures, and negotiations, from the letter of intent to occupying the space to ultimately vacating and surrendering it. A letter of intent or term sheet is a non-binding agreement that outlines some basic terms of the lease, such as duration and rent amount. This is the starting point to the conversation and helps you identify whether you and the property owner are in agreement about the broad strokes of the lease, leaving only details to be negotiated and confirmed. The letter of intent or term sheet is non-binding, but if there's vagueness or ambiguity in the lease agreement, then the term sheet may be used to illustrate a point of contention in a dispute. This is really the first opportunity to understand and identify whether this landlord is someone reasonable you can work with. At these earliest stages, also consider working with industry professionals. These include agents, brokers, and attorneys. They can help you identify a place that meets your needs and is within your means. They can also advise on the consequences and burden you are assuming by signing the lease. Because when it comes to signing your lease, you must carefully consider who will be signing. Are you signing as an individual? If so, you may be personally liable for unpaid rent, if any. Are you signing as an agent for your separate business entity? This is a reasonable strategy to protect your personal assets in the event of early termination or default. But you may be asked to sign a personal guarantee. A personal guarantee would mean that person, the guarantor, is assuming personal responsibility for the terms of the lease in addition to the original signor. If your landlord is insisting upon a personal guarantee, think creatively about how to limit or have the term expire before the lease ends. It's kind of counterintuitive, but this is also where you negotiate your move-out conditions. So understand early on how you are expected to vacate the space. Are you going to have to remove everything? Then plan for sizable move-out costs at the end of the tenancy. Are you surrendering trade fixtures? That may mean that the large build-out you carried out is going to stay with the landlord, even though you paid for it. Negotiate and familiarize yourself with the surrender conditions beforehand so you aren't surprised by move-out costs or the loss of property. So having exchanged the term sheet, the next step is to negotiate rent, which seems like an obvious issue but can have some unexpected outcomes. You need to understand if you're signing a gross lease or a net lease, and the difference between the two. In a gross lease, what you see is what you get. You pay your base rent, and that includes all the costs associated with the space. The rent amount is clearly delineated in the lease, and you pay that amount each month. On the other side, we have net leases and triple net leases. These are arrangements where you pay your base rent, but you also pay a series of pass-through costs on top of that. Some of these may be paid by the landlord and you are reimbursing them, while others are paid directly to a third party. Examples of pass-through costs include utility bills, costs of repair or maintenance of common areas, capital expenses for the property, in addition to assessed property tax and insurance. These costs can be very significant and increase your monthly payment substantially. So if you're negotiating a net lease, it is worth understanding your right to audit your landlord's calculation of these costs. And if you're a qualified commercial tenant under Senate Bill 1103, you can present your self-attestation and attempt to gain greater documentation and transparency around those costs. Understanding the difference between a gross and a net lease is very important for a commercial tenant, but there are other key terms that you should familiarize yourself with. For instance, assignment and subletting. These are viable exit strategies if your business does not perform or you need to end your lease early. In an assignment, the original tenant steps out of the contract and a new tenant steps into their place. The original agreement survives, but with new parties. A sublet, on the other hand, can be for all or part of the commercial space. In a sublet arrangement, the subletter pays rent directly to the original tenant, and the original tenant pays the landlord the full monthly amount. In a subletting arrangement, the original contract survives with the original parties, and there is a new contractual arrangement between the tenant and the subletter. Keep in mind that the landlord usually retains consent rights in the lease agreement to approve or deny assignments or sublets. But you can try limiting these by including language about potential candidates with sufficient financial history. It's also worth discussing repairs, modifications, and improvements. Since there's no statutory duty for the landlord to repair, the terms of your lease will dictate responsibility for maintenance and repairs. Oftentimes, even landlord repairs can be passed along to the tenant for reimbursement. If you're taking some period of time at the beginning to complete a build-out, consider negotiating a later rent commencement date and perhaps a tenant improvement allowance, subject to approval, to help with the financial burden of construction. Be mindful of insurance obligations, if any, and keep your security deposit in sight. Your landlord can use it to cover any unpaid costs attributable to you, the tenant. Your landlord can ask you to reimburse or replenish your security deposit if they have to use some amount during the tenancy. A lease agreement is a contract, and inevitably there are disputes. Here at BetZedek, we try to resolve disputes through negotiated agreements that meet our clients' needs. However, I like to inform people of certain details of civil procedure so they are prepared in the event of such a disagreement. Since lease agreements are for real property, they are resolved through what's called summary process. This involves your landlord delivering sufficient notice of termination of tenancy, usually through personal service or some other method approved in the lease. The notice will include an expiration date saying you must leave before it expires. If you stay beyond that expiration date, now your landlord can file a lawsuit for eviction. In order for your landlord to change the locks and remove your business's belongings, they must strictly abide by this process and be the prevailing party at trial or judgment. Then they can actually get a court order to retake possession of your commercial space. It's been a pleasure to discuss this important topic today. Our hope is to connect with commercial tenants before this becomes an issue. In an ideal world, people rely on this conversation to inform themselves and then seek out and negotiate a lease. This is important because SB 1103, the Commercial Tenant Protection Act, affords great new protections for small business tenants as defined under the law. These include clarity around sizable and significant pass-through expenses, as well as parity to other commercial agreements with respect to language access and language justice. If you are a small business with fewer than 5 employees, definitely educate yourself on the law and consider asserting those new rights. And commercial leasing generally can be a minefield if you aren't familiar with the terms. Consider working with industry professionals to help you navigate and identify your needs. Use a term sheet to clarify basic terms and be clear about your monthly rent payment so pass-through operating expenses don't catch you by surprise later on in the lease once it's too late to terminate. Understand that a personal guarantee keeps you on the hook for all the terms in the lease, even if you're signing as a corporation or LLC, and clarify move-out terms up front so you can anticipate any costs or losses looming at the end of your tenancy. Finally, there's formality to how disputes are resolved. This is a contract for property, and the law designates how different actors can assume rightful possession over the property. That is to say, you are not required to vacate simply because your landlord told you to. There are specific notice requirements and legal procedures to rightfully grant your landlord sole possession of the property, and this could provide leverage as you negotiate an early termination. If you have any questions about these topics, you are welcome to connect with us here at BetZedek for a more detailed conversation by visiting lalegalhelp.org or calling 866-375-9511. I hope you found this information useful, and thank you for watching.